Yes, thanks for having me. In fact, I was beginning to think that you had forgotten I was online because I'd hoped to join physically. But as you are aware, I'm also speaking I'm also a panel speaking on the theme for the mid-year conference of the GBA, which is happening as we speak. So thanks for indulging me to join you. Absolutely. As a human rights advocate, my whole learning training has been hinged on human rights. And so I do agree with you. And in fact, relish the engagements, the conversation that is going on there, as is expected of every jurisprudence, that continuously we need to do a check of our human rights framework. But of course, I'd hoped, and something I'm glad that later you redefine the comments you made, I'd hoped that coming from the office where I've been before, even there wouldn't have been the affidavit in opposition in the first place. So I think that is a comment I think later you addressed. But coming from that office, I'll tell you that no affidavit in opposition of that nature will emanate from the office of the AG without the AG being aware. It's good that now we don't have any.
This one, the application is actually from the state, so it will not be an opposition from the state, right?
So the objection, the withdrawal of the application by the AG the application shouldn't even have started in the first place.
Yeah, that's the point.
In doing justice to the conversation, you should have addressed that.
Yes.
But thank you. I agree with you totally. You and I think when you introduced me, said you're mate. I've always been a human rights advocate. I've shared this view. Of course, currently, the status is that it should be in accordance with the Public Order Act. And I've always maintained that if the conversation is that we have a real look at the existing law on demonstration, I am all for it. After all, it's the voice of the people through our representatives in Parliament.
If I may ask this, do you remember a single occasion where you supported the demonstrators against the police going for an injunction? Because there were even times you went for an ex parte injunction and we had to criticize you for allowing that.
Yes, you are assuming that the fact that you didn't hear from me on that side suggests that I was against it. I have maintained, and I spoke on the demonstrations when it happened, that there is a law. It is defined, there's a balancing act where there's a human rights are involved. And I have always maintained that it should be in accordance with the Public Order Act. It is different when you're saying somebody is acting, whether the AG or any other officer, contrary to the Public Order Act. And then we can have that conversation. But as the Public Order Act provides, and we feel that we need to close some gaps as we've identified in the Public Order Act, that is a different conversation.
Well, not about you personally, though, but I think some of the things that happened were extremely concerning and disturbing and really terrible, indefensible. But that was your job. You had to defend.
Public Order Act. No, I didn't have to defend.
I'm talking about even where you went for ex parte injunctions. I remember there was an ex parte injunction which granted the injunction in perpetuity. Yeah. It took the Supreme Court to set it aside. Yeah. On that occasion, I actually described the judge as incompetent, because if you're a judge and you don't know the basic rule, that you can only grant for 10 days and you grant for forever, that would be terrible.
And that's what I think I've texted you on the side to tell you that I disagree with some of your comments. The fact that you are dissatisfied with a ruling of a court or a judge in itself, there are rooms or there are fora for addressing this room. Are you suggesting, even remotely, that every judge must get it right? And whose right must he get it? Is it the right of an applicant, a respondent, or is it to get it right based on? So again, in exercise of the jurisdiction, it is not unusual for a judge to get it right, and that is why there are.
But for a judge to get such basic things so wrong, that's disturbing. Shouldn't it be?
No, something basic because you, Samson Ladin, says so. It may not be basic. It may not even be wrong in accordance with the other part.
No, it was wrong. The Supreme Court threw it away completely. That the judge was completely wrong.
And thankfully, but let's be sober.
It shouldn't have happened.
And in our comments and some of these.
It shouldn't have happened.
Always a two side in every matter in court. One side will always be happy.
Okay.
Both sides may be happy, which is a given.
Thank you.
But the fact one side is unhappy with the decision or dissatisfied with the decision does not lead to an absolute conclusion.
Yeah. So that's that. Thank you. Let's go to the other matter, substantive issue. And as you say, it's a disagreement, but respectfully, of course, I also disagree. I remember speaking to Godfrey Dami on this show about that issue, and he sought to agree with me that even though the judge has made a wrong, he will construe it as limited for 10 days rather than for forever. Thank you. Now, let's go to the suspension of Justice Tokonu by the President on the advice of the Council of State upon the establishment of a Prima facie and upon the establishment of the committee to, as it were, probe the matter. So, Dana, have you had the opportunity, for example, to advise the minority in Parliament or the NPP, as they say, that this is, let me quote what some of the comments that they have made, including at a press conference which Jerry Ahmed Saib, you and I, our mate, also had yesterday for the minority. They said the decision by the President to suspend the Chief Justice under the purported authority of Article 146 of the Constitution is nothing short of a brazen judicial coup, a reckless abuse of executive power, and a direct assault on the independence of Ghana's judiciary. This move, taken while legitimate legal challenges are pending before the Supreme Court, reeks of intolerable political vendetta, judicial intimidation, and a calculated attempt to pack the court with NDC sympathetic justices, as openly promised by President Mahama in Akosombo in 2023. Therefore, there will be a demonstration. What do you say?
Thank you, Samson. You asked if I've had the opportunity to advise the minority. I think you want to have a certain way to draw me out of my retirement, but the answer is no. But then you asked me what my I think my view so far I've made clear, and I stand by that position, is that something, again, we have to have a very sober reflection on the whole import of Article 146, appreciating against the backdrop that it is not a low threshold, and we should not sink our democracy by dilly-dallying or minimizing the effects, the import in the implement of Article 146. I have maintained, first of all, I've come out publicly to condemn the leakage, even from government communication officers, by posting it, some even on their Facebook. Now, again, you ask me what my comments are. And then I hear comments that say that, what has the president done? And that comment usually is laid with the assumption that there can be nothing wrong so far with the process. I reiterate, my position has been that there is no basis whatsoever for finding a prima facie case in respect of at least the 3 petitions that have come. And I'll go on to explain why. Can the president do something wrong in accordance with Article 146? Absolutely yes, because the whole purpose of Article 146 is guided by the Constitution generally and by the very provision of Article 146. Now we see the suspension, and need I say that Clause 10 of Article 146 gives permits by way of discretion, the exercise of discretion, for the president to exercise this discretion to suspend the Chief Justice. And constitutionally, the exercise of discretion is again measured by the very Constitution in itself, Article 296, as elaborated in the plethora of cases by the Supreme Court. And so can the president fault? Yes, he can, in the exercise of discretion, where it is contrary to the very provisions of the Constitution. Now, coming to the very fact of this case, my position has been that there was no basis for the exercise of the discretion. And I'll say again, that first of all, if the only communication to the Chief Justice indicates without more that I have established a prima facie case in respect of the 3 petitions, the question is, will that alone suffice that the test under Article 296? I do not think so. Secondly, you look at the basis of these three petitions in substance to determine that even if on the face of it, a prima facie case may be made. Again, I do not think so. And I'll come back to it. Sam, if you look at the petition of, is this Savior Group or so, where the thrust of the petition is on two fronts. The first being that the Chief Justice recommended to the President, giving some reasons why the number of justices on the Supreme Court should be wider, it should be more. And then you say that that is a ground for petition for removal. Practice, as you are aware, is that the appointment of justices all throughout go through a process, including consultation with GBA, Judicial Council, etc. In any case, that letter that the Chief Justice wrote was a mere recommendation. We know the import of recommendation or even advice to the President. It is not binding on the President. Indeed, it shows that the President did not even proceed to act on that advice of the Chief Justice. And so for me, I find it questionable how such point stated by the Savior Group can present a ground for the establishment of a Prima case. Second, and most importantly perhaps, is that the thrust of the petition of the group is that the Chief Justice, while sitting as a panel member of the Supreme Court, and you and I know that the Supreme Court's jurisdiction, unless it is a single justice of the Supreme Court acting on behalf of the Supreme Court, usually is not fewer than 5 justices of the Supreme Court. And so if the basis of the petition, which then ends up in the finding of a prima facie case, is that the CJ, who has 1 vote, just like all the other 4 judges on the panel, while sitting as a court, made certain decisions, gave certain orders that you are not satisfied with, the ground for it, I believe, is not Article 146. And I've always maintained that the Constitution and our laws in themselves present avenues for challenging decisions of the court. Now, I always tell people that I'll draw your attention to the very deep statement made by then Professor Justice Dateba in the Judicial case. Now, if you remember, there was a preliminary objection raised by one of the parties that this is a dispute in respect of the petition to remove the Chief Justice. So how can the Chief Justice himself, then Chief Justice Akwa, empanel the member to determine this matter? And Justice Dateba said something, and I admonish all Ghanaians to take a careful look and reflect on that statement. Indeed, he said, and I quote, that we, the rest of the judges at the Supreme Court, are not malleable clay in the hands of the Chief Justice. In other words, we have our independent thinking. We have our own, as it were, objectivity. So to suggest that we will be influenced by mere reason of the paneling of the of the Chief Justice is unfortunate. And I do agree with him. And so for the petition to suggest that the Chief Justice, as part of the panel, as part of the court, made certain decisions, with all respect, is an insult to the rest of the justices that sat on the panel with him. In other words, they were so malleable that some of the decisions, which were unanimous, they were controlled by the Honorable Chief Justice. And I do not think that is a fair statement to make against the other justices of the Supreme Court. In any case, if you are dissatisfied with that decision where the Chief Justice presided, there are avenues for expressing that dissatisfaction. And secondly, when the Chief Justice sits as part of a panel, she could even be part of the minority. She could express a dissenting opinion. It is a decision. It is the order of the court. It is not a decision of Gertrude Tokunu. It is, and again, let me go back. I don't like to even use personalities when it comes to issues of the judiciary. Especially, I mean, something is so coincidental that the first time I appeared on your show on Newsfile was in respect of matters on the judiciary. And I have been consistent that in as much as we have the right to criticize, to be dissatisfied with decisions of the court, we have to be careful about not destroying the very tenets of our democracy. Because the judiciary continues, even on 6th January, when all the other arms of government are giving way after election to other parties or government to come into power. And so let's be very careful. And so to say that a decision of a court and not a decision of Tokonu is a basis for establishment of a prima facie case, I'm afraid I do not agree to that. You look at the other petition by Daniel Forey. Indeed, at paragraph 5 of Daniel Forey's petition, he says boldly, and I quote, that I am not required to produce any evidence to support any of the allegations I have made in this petition. And that is a basis. In fact, we saw that, but for the request by the CJ for copies of this petition to even assist the court in determining these mere allegations, bare assertions that were made by Daniel Forey in his petition, do we say suffices for establishing a prima facie case? I do not agree so. Again, in the same petition, he alludes to certain things that are including the exercise of some administrative functions without proof. And so something might fear, and that should be the fear of every Ghanaian, that somebody puts pen to paper, makes bare assertions, mere allegations against you, and that suffices as a basis for prima facie case. I believe we are lowering the threshold for the exercise of that constitutional process to remove no meaner person but the head of another arm of government, which is the judiciary. Similar arguments can be made with respect to the Apogo Ayamda case. Again, and he is the only one that attaches a newspaper item to his petition. And go and check that newspaper reportage of Law Platform at that time. He said it is only Tokonu who caused for his arrest. Again, sitting as a panel. And in that same exhibit, which he attached to his petition, you will find that the newspaper reported that even Justice Prima made interventions to him and said that you cannot be this discourteous to the court. You cannot be this violent to the court. In other words, your act, as it is now, is being in contempt of the court. And we do not see any of the judges signing to say that they did not agree with what happened on that day. And so, Samson, I'm saying that I'm not being dismissive. If you have a grievance, if you have any dissatisfaction with any act of any judge, more so the Chief Justice, I'm not saying that we are gagging you from expressing that dissatisfaction, but I'm saying that our very Constitution and the laws we have given to ourselves provide specific avenues for addressing these grievances and dissatisfaction. If you are saying that the processes are not sufficient, that is a different matter. Okay. And again, let me emphasize before I conclude on this that please let's not get the discussion wrong. The discussion for me has never been about personality. And that's why when I mentioned Petition, when I go back and say at the Chief Justice, the discussion has never been about person. The discussion has always been about the office, has always been about the institution called the judiciary, an arm of government, which is no mean part of the democratic dispensation. All right. Part of our democratic dispensation.
Okay.
Thank you.
So a couple of questions for you, especially because you take leave of us midway or very quick soon. And I'll be glad if you could just be straightforward with your answers and as brief as you can. So did you have to speak to this matter before the petitions were leaked?
Sorry, did I have to speak to it?
Did you speak to this? Did you speak to this matter before the petitions were leaked?
To it when it was leaked. The question is when you had it when it was leaked, but it had always been leaked, and that was the time I spoke to it.
Okay.
And found that if this is the leakage, then right. I'm afraid it doesn't cut it to meet the threshold for establishing a prima facie case.
So you are faulting those who establish a prima facie case that they did wrong. Is that what you're saying?
My position is that there is no basis for establishing a prima facie case.
Which is your view? Which is your view?
In accordance.
Okay. So you see, a while ago, we're talking about a judge's decision. And a judge made the most basic, simplest, fundamental error I don't expect any judge to make by making an ex parte injunction a perpetual injunction, which should never happen. And you said, you know, it's okay if a judge makes that and then it can go on appeal.
I did not say it is okay.
All right.
I did not say it is okay. I said that if you or any other person is dissatisfied with the decision, you see, if I can't say that judges making a decision, I'll be privy to the details of the reasoning they give for each case. So I'm saying that, are there avenues for addressing our views when we are dissatisfied with the decision of the court?
Right. So
in the confines of the jurisdiction, they can't get it wrong, and they do get it wrong sometimes.
Okay.
But is that a ground for an Article 147? I disagree with that.
Okay, thank you. So that is your opinion, that is your disagreement. And you will agree that your disagreement cannot override all the other people who may have been involved, particularly the Council of State, who would have been involved in the prima facie determination. So that's your disagreement. Now,
that their position makes a superior argument in accordance with the Constitution and the law, then I will agree with you. But I have taken time to express my view in accordance with the law. And I'm saying that if your petition is that the CJ sat as part of a court.
No, it's okay. It's okay. Let's move on. Let's not repeat the point. Thank you. Let's not repeat the point. Okay, and I'm in a very difficult situation here, and I must confess, also because of the individual involved. But let me ask you this. So, myself, my senior, there was a matter in which a High Court judge sat on, and we found that something wrong went on. So he gave a decision against us, but we had to appeal because we know we have to appeal. But we had to make a complaint, and in the complaint, the judge was found to have misconducted himself, and he was giving a reprimand. Let me tell you what happened. Any day we went to court, the judge had conversations on phone with the lawyer.
Without seeing the proceedings and the decision in that matter. I'm just.
If you allow me to finish.
Don't expect me to.
If you allow me to finish, please.
I'm just saying so that you know how to present the case to me.
So you see, when you were making your presentation, and that's what I do on this platform, when you were making the presentation, I gave you sufficient time to finish. Now I'm coming to ask you a number of questions on the things you made. So I'd like you to be patient with me in that regard. So I'm saying, to the point that you are suggesting that if a judge makes a decision sitting qua judge by Article 127, Clause 3, the judge is not subject or liable to any action, including in a court of law, for any omissions or wrongs they may have done in performing their judicial duty. That's the point you are making. So I'm giving you an example of a situation. Whether you believe it or not, that's different. But I'll not sit here and tell a lie about this. So we found that if I can ask, we found that this judge, any day we went to court, spoke with the lawyer on the other side before we went to court. There were times that the judge actually spoke to the lawyer after we had finished court. So we procured the telephony record in our, complaint to prove that the judge had misconducted himself. So this is a situation where they have done their work in the courtroom, but we find something else to show that what they have done in the courtroom is wrong. You see that we are allowed to still challenge what they have done in the courtroom, even though it is not by an appeal, correct?
So something, again, and you and I are not speaking different. I'll tell you what, if you read the A.G. case very carefully, Justice Bar and the Supreme Court, they address all these issues. That it is not as if even the administrative action may be absolute for immunity. But what you are, the narration you're giving is quite peculiar. You are talking about ex parte communications with a judge and one of the parties. But we don't see a similar thing in the petition by Xavier or Kogo. It says the court gave an order. It never said that the Tokonu had it. So again, that's why I keep saying that when you come to the nuanced application of the law, we may end up differently.
Okay. Now
there was no ex parte communications from the petition we saw. It says, and go back to the petition, that the court that CJ presided So I'm asking myself, what happens to the other 4 judges who sat with her? Why are they also not being removed? Because that is not a basis for Article 146 removal.
Okay, so the point
the law, and that's why when the plaintiff lawyer and the defendant lawyer meet, they will all be invoking the same law, but it is in the application of it that grants itself to a judgment. So expert communications are different.
Okay, so the point I'm seeking by the reference I made was to bring to your attention whether you think it is possible that Article 127 may not always apply generally. Article 127, Clause 3 says, a justice of a superior court or any person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of the judicial power. I'm not saying that any petitioner has suggested that there's an ex parte communication that they can fault the CJ on. Now, you say that the exercise of the discretion or the determination of the prima facie is not compliant with Article 296. How can you explain that?
So the exercise of the discretion in itself is not absolute, and the exercise of every discretion under the Constitution, as we see from 296 and as elaborated upon by the court, must have a basis, the test for the exercise of that discretion. And I'm saying that very basic examination of the petitions, it's that it is, I am aggrieved because the CJ was part of a panel that decided a matter in which I am dissatisfied. And I'm saying that is not a proper exercise of the discretion to arrive at a prima facie determination.
Do you agree that it is possible?
Let's all fear of the conversation that there can be no question whatsoever to the exercise of that discretion under the Constitution.
I'm not veering off a conversation. Wait, Dinah, hold on.
Let us veer off.
Dinah, hold on.
I say you something. But I'm saying let us veer off that conversation.
Okay, Dana, hold on. Let me.
There will be nothing wrong in the petition of Article 146.
Oh, can we do this, please?
Something wrong, particularly when is the exercise of a discretion.
Okay, Article 296 that you are referring to. Is it this portion that you are referring to, which says that where in this Constitution or in any other law, discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. The exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. Is this what you are referring to? Is this what you are referring to? We're having a little difficulty with your line. Hello, Dinah. Hello, Dinah.
In the case of that
your line is breaking. I suppose, can we call her on phone so we can finish with her? Yeah, hello, Dinah.
Hello, can you hear me?
Yes.
Yes, I can hear you now.
The part I have read, is that what you are referring to? This is not helpful. Yeah, she can't hear me. Sorry, I'm talking to my production as if... Hello, Dinah.
Can hear you. Yes, I can hear you.
Okay, so I asked the question.
It's just that I see that I've been disabled from my video. Hello?
I hear you. I hear you now.
Especially when
I hear you now. Hello, Dinah. Hello, Dinah. Hello, Dinah. Hello, Dinah. You have to stop making a presentation. Answer my questions. Help so they can answer my questions. Can you hear me now?
I see that I've been disabled by the video, and I don't know if also you can't hear me, but it says you've been disabled. You cannot start.
I'm hearing you now. I'm hearing you now. So the disability thing, I don't know. Please, can we call her on phone and finish this? Please raise Dinah back on phone. Let's cut this one.
I've seen that it says that he's allowed me to restart my video. Yes.
Okay, so I said the portion of the Article 296 I read. Is that what you meant?
Yes, that.
Thank you.
Shall be.
I want a yes. I want a yes. Then I'll ask you the next question.
Yes.
Thank you. Which part of this has been breached in the process? Okay, so let's cut it. Let's not continue to stay on the Zoom. It's not working. She should get on phone, and so we can quickly get done with her. Yes, so production, please get her on phone. That's how we do it, because we waste time. So she says a few things that we should not sink our democracy by this process. There's been a wrong use of discretion, not compliant with Article 296. Bare allegations have made a prima facie determination, and so on and so forth. And a judge exercising her duty in a panel is not to be singled out and blamed. And even in that manner, it is exercise of the judicial duty. So you can't even take it to any forum, including a court of law. So quick thoughts, Oliver, before I get back to her and finish off.
I mean, we need to go back first to Article 146. Article 146 says the grounds for removal are stated misbehavior or incompetence. What is a judge competent to do? It's the first question I ask myself. Because we say that legislator does not use two words where one will suffice. So if you have said misstated misbehavior and we have said incompetence, it implies to me incompetence in respect of the judicial function for which you're competent to perform. Okay. The mere existence of a forum to address incompetence does not eliminate the incompetence in itself. So if the constitutional intendment is that we want to do away with Kekewich, for those who are not lawyers, is that Kekewich has become famed for judge who continuously made wrong decisions, then that's the constitutional intendment. So it can never be the case that because a judge has made a judicial decision, that decision or by conduct had shown consistent incompetence on the bench, that we cannot remove that judge. We did not case ourselves with incompetent judges. So it's a strange argument. In fact, I remember years ago when that conversation you just had about that injunction came up. It affected us. And when you have raised the issue with me, I said, I understand it, but I'm even afraid to contemplate it. Not that I am dismissing that it can be a possibility. So to come into the conversation now and say that this is absolutely not even within the constitutional imagination, I think it's a disservice to the conversation. Of course, the judgment and evaluation as to whether or not on this occasion the Chief Justice or any judge has been incompetent, that is the job of the committee that has been instituted to do. So we cannot say that any petition which raises the possibility of judicial incompetence should be thrown out ab initio. That I am struggling with will be my initial comment, I would say.
We get Dinah on phone. It is important. She's the former Deputy Attorney General, a former Deputy Attorney General and Deputy Minister for Justice. Her party is the one that is rallying support for a protest. Her party is the minority in Parliament that is saying that what is going on is basically unconstitutional. And with the benefit as a former Deputy Attorney General, we want her to educate us on the points that she agrees. My view is not important here, and I actually don't intend to speak about the content of the petitions for myself, but you are free to do so like she has done. Now, yes, Inusa.
First of all, in fact, I will not go into the content of the petition. I am a constitutionalist. I understand the tenor of Article 146. I understand the reasoning and rationale behind the proposition that everything concerned with the removal of justices of the Superior Court of Judicature and Regional Tribunal must be in camera. I've read fully the judgment of Databa in the Ajechum and Attorney General and another, and he deprecated in forceful terms the leakage of petitions for the removal of the Attorney General. So let me say that I am going to restrain myself from talking about the petitions, and that is my shock in the account of the former Deputy Attorney General. What she has done simply is to substitute herself for the committee that has been established under Article 1466.
She's entitled to disagree with them.
No,
that's what she has done.
Well, so she disagrees with the committee and takes the petition, and she's now analyzing the petition and drawing conclusions.
She hasn't said anything new. She has simply repeated the responses, quote unquote, the responses from the CJ. That's what she has simply repeated to you. Hold on, I understand that Diana is back. Hello, Diana.
Hello, Sam. Can you hear me?
Great. Good to have you back.
I could hear you.
Great.
Perfectly.
Yes.
I could see you. In fact, I could hear a response that the subject of the incompetence to the judge is not what we were looking at. I mean, absolutely, the ground is for incompetence. The view then is, what are the other judges who sat on? Because there was a decision not of the Chief Justice, but a decision of the court, constituted by no less than 5 justices.
Right. You say the Prima facie was not compliant with Article 296. I'm asking, which part of 296 would you say has been breached?
Hello, Sam.
Yes.
That has been my position, that it was not in compliance with 296 and decided cases, and particularly when we look at the article the president has consistently made against not just the full members of the judiciary, but especially in respect of the justice. I am saying again, I'm on another panel as we speak. Again, my position, I will reiterate, is that we not, in fact,
okay, sorry, we are unable to continue. The line is bad. Thank you very much.